Good afternoon. We're clearly behind the schedule, but we'll make up in quality what we lack in terms of time. You can depend on that. So welcome to you all to this panel discussion. The topic is in front of you there on the screen. It's a truism that the subject that the panel is going to address between now and lunchtime may be new to some and familiar to others. Nevertheless, it's something that we individually and as groups, national and international groups, need to understand more deeply so that we can make a positive and constructive engagement to it, as you will see. So what is the context for this? In effect, the sessions over the last 24 hours have provided that, our context. The key issues have been well highlighted in Melissa's session that has just been completed. Last night at dinner, we received an overview of the new US international strategy for cyberspace from Christopher Painter. The consistent theme there has been that the urgency and importance of ensuring that national economies and international trade should be enabled to flourish, realizing the benefits of advances in technology. And we need to bear that theme in mind on this particular topic now. Speakers have also pointed out that the risks and threats that have accompanied these advances are outpacing law enforcement. And I found that slide that was shown to us yesterday particularly telling as it illustrates that issue. And there's the law enforcement work area lagging seriously behind the exploitation of technology by the villains of the peace. Organized crime and individual criminals have continued to exploit the advantages presented by web technologies. Many have failed to recognize this, and because they've done so, the villains are able to exploit the avenues for making money. Consequently, serious data losses through theft and incompetence have continued across the public and private sectors. And that obliges all of us to have in mind this question: why has it taken so long for the boards and for individuals to get this message? I believe we have to develop an effective response to that question as this expert community starts to address new and pressing issues such as privacy and law reform. And I'll pick this up in my closing remarks. Recent media interest in the UK, as many of you will have seen, has highlighted the real tensions between individuals' views of their right to privacy and the media's expectation of freedom of information and their right to know and to publish. The vigor of debate indicates that this is timely now to review legislation and regulation in this area, hence the topic of this discussion. And I believe the aim of this panel is as set out there. We'll seek for you to identify the key issues, the implications, and the underlying principles that should shape evolution of legislation and regulation that will be fit for this information age. To launch this discussion, we've assembled a hand-picked team of experts, each of whom will speak for no more than 8 minutes. I have my eye on the clock. And we will then raise questions across the panel and then open it to discussion within the remaining time available. So first, I'd like to introduce, on my extreme left, Stewart, a barrister and solicitor and partner at Field Fisher Waterhouse in London, who has particular interest in privacy and information law matters. You should know that he's the author of an impressive practical guide to UK data security laws, to regulations and to lessons learned from recent security breaches, and I commend that to you. Stewart, over to you.
Thank you ever so much, Sir Edmund. I just wanted to expand a little bit more on my context and perspective, because the propositions I'm going to make are highly controversial, or at least are viewed as such in some areas. But this is my context. I've been a practicing lawyer for 20 years now, and for the last 10 years I've been working on privacy, security, data protection, telecommunications, and other informational handling legal issues. And in this time, I've represented people in cases against their employers for overzealous surveillance in the workplace. I've acted for other individuals against corporates who've misused their online data footprints for commercial advantages. But I've also defended corporates against overzealous regulatory actions following data security breaches and other data loss events. And that's included going toe-to-toe with the Crown in the criminal courts, defending directors of small SMEs from false accusations of data theft. And within all of this, handling data security breaches virtually every day of my working life. So that's the perspective here, and I apologise at the very beginning for that exceptionally hubristic introduction to myself. But it's my perspective and context for what I'm about to say. And this is my central point, that there is, in my view, as a lawyer steeped in this area, a compelling case for root and branch law reform to introduce a general obligation for security. So that's my point, the introduction of a general obligation for security, both nationally and internationally, by which I mean that the holders of sensitive data and the controllers of important networks, systems and infrastructures and their supply chains should face a clear legal obligation to keep these assets safe and secure. And as well as describing this obligation, the general security law should describe the consequences of failure, by which I mean penalties, sanctions, and rights to compensation. So let me tell you why I make this proposition and why I hold this opinion. Well, the first point is obvious, and it's what we've been talking about for the past 2 days, that the threats to these assets are considerable. As such, a general obligation for security would be a proportionate response in light of those threats. Secondly, I do not follow the creed of enlightened self-interest. In my view, it would be naive to think that all relevant actors will do what is necessary to protect these assets without a clear steer from the law. Ignorance, laziness, apathy, short-sightedness, greed, these are all powerful counterweights to enlightened self-interest. And thirdly, I'm deeply concerned about the privacy and data protection angles. So let me explain what I mean by this. In the United Kingdom and in the rest of Europe, the law for security is effectively left to reside in the domain of privacy and data protection law. And I believe that that is a grave mistake. Firstly, it gives the mistaken impression that the law only sees security as being important in the context of the handling of personal data. But of course, we all know that the substance of security extends much further than that. And the impact of this problem is worsened by the fact that far too many people and organisations do not take data protection or privacy law seriously. Thus, the law is presently not driving the correct behaviours. Secondly, the way the law is now structured forces the topic of security to be viewed always through the lens of privacy. I believe that a worse result could not be designed. The security privacy issue is already complex enough without the law automatically imposing this unhelpful perspective and requirement at all times. And thirdly, and this is my most important point, the way the law is now structured effectively gives ownership of the field for security to the people who are the least competent or equipped to manage it. What I'm talking about is a small cadre of data protection regulators and bureaucrats who are so slanted towards privacy that they unwittingly encumber us with anti-security results. And these effects can jeopardize the health of cyberspace, our economies, and our societies. Let me make one point clear. I am a staunch supporter of privacy rights and data protection. That's why I fight for these rights for individuals all the time. But I'm also a staunch supporter of good security. I see security as being the bedrock upon which the enjoyment of our fundamental rights and freedoms rest. Security is a guarantor of liberty and freedom. In other words, I say security for privacy, not security versus privacy. But to achieve the correct balance, we need to decouple security and privacy law within our legal frameworks so that the cart does not drive the horse. A law reform process that delivers a general obligation for security will deliver much better results than the current disconnected legal framework. So what will this general obligation for security look like? Well, aside from removing the issue from the privacy and data protection domain and describing the nature of the obligation to secure assets and the penalties that might flow in breach, a general obligation for security will capture the following issues. Definitions. What are we talking about? What is the substance of our concern? It will also deal with the traditional cybercrime subject matter, dealing with the criminalisation and prosecution of unacceptable behaviours of hackers, botnets and others whom attack information and information assets. It will make clear the role of the private sector, particularly the private sector IT security industry, so that innovation in IT security solutions can continue. Our reliance on the private sector is total. And it will also contain the legal framework for intelligence sharing between the public sector and the private sector and across geographic boundaries. And it will deal with the need for identification measures for people and machines operating in cyberspace. One of the problems of privacy law owning this issue is the fact that it provides a cloak of ambiguity for the antisocial and criminal behaviour that we're concerned about. And finally, perhaps more controversially than all the rest, this new general obligation for security will describe the right for people and organisations under cyber attack to take offensive action in their defence. I know this is controversial, but we need to debate this issue and ask ourselves two questions. Firstly, is it morally right to tie the victims to purely defensive strategies? And if it is not morally right, is it safe to open Pandora's box and allow people to fight back? In conclusion, responsible governments around the world who are serious about addressing cybercrime and other cyber ills are left with no alternative to exploring the legal structures that will deliver us robust security for now and into the future. It's a mature debate that can be started and must be started in this area. I believe it would be a profound step along the path to identifying the appropriate rules of the road for cyberspace if we started to engage with these issues. Thank you, Sir Edmund.
A very pithy overview of a highly complex topic. Our next overview comes from Stephen Deadman from Vodafone Group, the privacy officer and head of legal, head of privacy, head of security and content standards. Stephen has, as you will have seen from his bio notes, a wealth of experience in the development of global privacy policy and strategy, both in the international and national mobile industry community. Stephen, over to you.
Thank you. Thank you, Stewart, for that overview too. I'm going to give a slightly different perspective here, which is the corporate perspective on this question of the right to privacy. And what I'm going to try and do is answer that question, and let me do so unequivocally. The answer to the question from our perspective is yes, the law does need to change. Let me give you some context for what that means for a company like Vodafone and explain why and some of the things that we think need to be changed, which in a sense are quite tangential to some of the things that Stewart's just talked about from the perspective of where does the divide between privacy and data security rest. The first thing is trust is the cornerstone to our business. As our customers spend more of their lives on their mobiles, texting, calling, tweeting, posting, uploading, downloading, they leave an ever-increasing information wake. And that information wake requires companies like Vodafone to build trust in the fact that the information will be kept secure, and customers expect Vodafone to respect their privacy, even where aspects of what it is they do is not in the control of companies like Vodafone. If customers don't trust the services that they're using, don't feel that the devices they're using are secure, then they don't use them, and that's a bad outcome for business. So it's clear to companies like Vodafone that trust is a key enabler for success. And needless to say, we operate in a competitive environment. If you don't like the services you get from companies like Vodafone, you can go elsewhere with relatively little ease and take your mobile identity with you. But trust is also the cornerstone of the development and growth and the potential of the digital society. We need to be able to trust what we read on Wikipedia. We need to be able to trust the recommendations for sellers on eBay. And likewise, we need to be able to trust that when our kids go online, that they won't get stalked or groomed. And all of this needs to happen within a regulatory framework that enables governments and regulators to protect the wider societal interest. Governments need to be able to take action to deal with national security threats and cybercrime, and equally need to be able to tackle threats to privacy and data security. So, does the existing framework provide the right framework to deliver trust? Our view is that, as it is now, it doesn't. Let me take a look at some of those changes that need to take place. If you look back to 1995 was a seminal year for data privacy development in Europe. It was the year that the European Union adopted the Data Protection Directive, the first comprehensive form of legislation of its type. And what it sought to do was address the problems that it saw at that time. And very quickly, let me describe what that was. Personal information was being collected about individuals, data subjects, as they're referred to, by largely enterprises, referred to as data controllers, and processed and handled within largely segregated silos, principally mainframe computers. In that context, the individual was very much a passive bystander in this interplay of collection of data and processing of data. The enterprise was static and stable. Their information systems were generally disconnected from other information systems. And so the framework was a framework that set up a set of rules which regulated how these data controllers collected information about the data subjects. Now you might say, well, that sounds all right. We need that kind of framework now and going forward. And I would say, yes, you do, but it's by no way enough to tackle the sorts of problems that we're seeing now. So today, if you look at an industry like mine, in 1995, telecoms companies were providing services in a vertically integrated manner, and it was really quite slow and simple. But today we have all manner of companies providing voice communications, enabling us to tweet and post content, access the internet. So the communications environment is now fragmented, it's distributed, it's rapidly evolving, very competitive and very disruptive. Services are often provided across borders by entities that may not know their obligations in the markets in which they serve. And even if they did, they probably don't have the capability to actually deliver against those obligations. And of course, there are still large enterprises that are collecting data, but today, every single enterprise is now collecting and processing personal information about customers and citizens. And even the large enterprises are increasingly fragmented through greater use of temporary consultants, through greater offshoring and outsourcing. So the nature of the problem today is fundamentally different to the way it was conceived in the early 1990s. And it presents a major challenge for regulators and policymakers. So I want to make 3 points about the constraints in the existing framework. The first one is this. Going back to the point about data subjects being passive, the passive data subject has been replaced by the active data citizen, where all of you are no doubt now tweeting and accessing your Facebook and doing many other things where you are creating the digital dossier about your life. So the individual has moved from the periphery to centre stage. And increasingly, this is where the debate about privacy and what it means for us as a society and the growth of our economies is being discussed. So as the individual moves to centre stage, the individual is increasingly taking control of their own information. And as they do so, they become dependent upon the platforms and the technologies that they use in order to protect their information and protect their privacy. So a significant component in the information ecosystem today is the platforms and the technologies that we use in order to get access to information and to share information. Which leads me to my second point, which is that the concept of the data controller, that 1995 concept, is no longer enough to capture the full range of different actors within the information ecosystem. So we need to extend the law to cover those new types of intermediary that we see emerging, the social networks, the app platforms, and so on. And it's in this area where concepts like privacy by design, a favourite buzz topic for privacy regulators, really has the biggest impact to play. And this leads me to my third point, which is arguably one of the biggest challenges and an area that's caused the most debate within the field of privacy law and regulation, and that's the global nature of the internet. The problem is one of regulatory reach. If the organisations that build the services and develop the technologies are operating out of distant headquarters or indeed no headquarters with very little knowledge of the legal, regulatory and standards environment into which they provide their services, then this becomes a very serious challenge to policymakers and regulators in effectively enforcing the law. So regulators need to explore new means of enforcement. Direct cross-border enforcement will remain a lengthy and resource-consuming process. Our view is that regulators, governments and the private sector need to come together to look at enforcement mechanisms to ensure that standards, laws, privacy, security can adequately be enforced in the markets in which those services are being consumed. So government should work in partnership with companies like local operators to help regulate the internet, such as identifying or blocking spam or malware, preventing access to known illegal content, and preventing the download or use of apps or services that violate privacy standards or create other cybersecurity risks. So our desire is to see a strengthened privacy framework, not a weakened one. The benefits of the internet, the low barriers to entry, resilience, distributed services and flexibility also make it difficult to regulate. So regulation has to have two objectives. Firstly, keep it open, keep it free, keep it competitive and innovative, but at the same time make sure that it's safe, it's secure, it's privacy respectful, and it enables companies to comply with the law. Thank you.
Stephen, thank you. Our third speaker is the Honourable Michael Chertoff on my immediate left, former Secretary of the US Department of Homeland Security, former federal judge and prosecutor. He'll need little introduction to this community, but I believe we're most fortunate to have an individual who can give us a genuinely strategic overview of an important subject. Michael.
Thank you. Well, I think the message of this panel is that we are in violent agreement with each other about the need to have a change in the law governing the issue of cybersecurity. I would say at this point we are laboring under a set of 20th century laws that are poorly adapted to a 21st century problem. And that's why often the discussions that occur about what can be done, who should do it, what the limits are, and the supposed tension between privacy and security emerge because we're thinking in categories that are not particularly relevant. For example, whether people ought to be prosecuted or whether there ought to be some direct intervention in the internet to prevent malware from coming into a system. Who ought to take responsibility for safeguarding data and how that rests in tension with the need to investigate when there's been a data breach. All of these issues emerge, in my view, because we are taking concepts that were built for a different era and a different set of concerns and trying to see which ones we can stretch to deal with the existing set of facts. It's a little bit like, the old saying, if you walk around with a hammer, everything looks like a nail. So the police look at all the cyber problems as criminal problems. The military has a different view. The privacy advocates have yet a different view, and it's not helpful in terms of integrating all of this together. So my suggestion is we begin with a clean sheet of paper, and we think about what the doctrine is of cybersecurity that we want to promote, and only then do we construct a legal architecture that supports that doctrine. Now, I don't mean to suggest that this is a matter without controversy, because when I talk about doctrine, I mean questions such as what is the respective role of the government and the respective role of the private sector in safeguarding networks, and does it matter depending upon whether it's a government network, critical infrastructure, or a purely commercial network of only local or regional significance? What are the authorities the government ought to have, or the private sector ought to have to undertake defense? I mean, Stewart raised an interesting question, for example. Do we believe that in the effort to pursue someone who has exfiltrated data, we should have the ability to go back and reclaim that data and potentially disable the server, which was the source of the original intrusion? And if we believe that, who should enjoy the authority to do that? Should it be the private sector? Should it be the victim? Or should it be the government? You can debate this both ways. Some would argue they don't want to have the government on the Internet at all. They see, as soon as they hear the word government and Internet in the same sentence, they break out in hives. Others would say that in the physical world, we don't allow victims of burglaries to self-help by going to the burglar's house and reclaiming the stolen money, so we ought not to let the private sector do it. But the point is, this is a matter that has to be debated as a policy issue. Certainly a third element is to look at the question of capabilities. Who ought to have the authority and who ought to have the responsibility should be a function of who has the capability. And if we believe that the authority and responsibility should rest with one particular type of actor and not another, and that actor lacks the capability, then we've got to invest in building that capability. But again, that only emerges when you talk about a doctrine. And so I think that what we need to do is to think about where we think the appropriate roles are, the authorities and capabilities, looking across the entire landscape of cybersecurity. And in this regard, it's clearly important to distinguish between matters that are criminal and may be serious to victims versus matters that affect the either security of the state or life and limb, as, for example, when we talk about the possibility of an attack on critical infrastructure. But we also have to recognize that sometimes the embedding of a tool in a network is not clearly pointed in the direction of either data theft or in the direction of data destruction. Sometimes the tool is capable of doing both or either, and so that introduces additional ambiguity. The third point I'd make is on the issue of whether privacy is in fact in tension with security. And just to give you two examples, I've had situations in the private sector where there is a network intrusion or potential network intrusion that affects not only the enterprise, which owns the network, but also the privacy of all the employees who operate on that network. And, of course, they operate on sufferance in the sense that they're told that they don't own the network and they don't have any intrinsic privacy right. And nevertheless, when there is an intrusion and the network owner wants to look and see how that intrusion came about, which in many cases involves looking to see how individuals use their particular workstations to interact with the Internet, certain regulators say you can't do that. That invades the privacy of the employee. But note that that is a triumph of form over substance. We're protecting the privacy of the employee against the owner checking to see where that employee has been on the Internet, and in doing so, we're sacrificing the privacy of everybody else on the network. And a lot of this, frankly, comes from a philosophy certainly prevalent in the Western world, maybe a little bit more actually in Europe than in the United States, that sees the cardinal threat to civil liberties as the government. And that's obviously got a historical pedigree that's understandable. I would suggest, though, that in the modern age, and particularly in the cyber domain, individuals and non-state actors are capable of visiting a kind of injury and destruction on individuals that is very comparable from a civil liberty standpoint to what the state can do. And so we need to rebalance our sense of where the actual threat is. And so therefore, my argument is this. As we build this new legal architecture, we have to recognize there can be no privacy without security. If I make a commitment to protect data, that commitment is only as good as my ability to carry it out. And all the rules in the world that say I have to make promises about personally identifiable information are useless if I'm not given the ability to protect that information on my network from third parties. So I think there's plenty of work to be done, but if I was going to leave you with a single message, it's this. Please do not make what I perceive to be the common mistake of starting with where the law is and trying to figure out how you can force the law to fit the facts. Rather, look at where the facts are and then look at how you can make the law, draw up the law, and develop the law to fit the facts as they are in the 21st century.
Michael, thank you. I'm going to make the assertion that the case has been made for change, and that last remark is one that should remain ringing in our ears. This is a case for an intellectually new start to a new environment, almost from first principles, but taking heed of lessons identified from past disasters and misadventures. Now, I'd like just to develop some of these themes before we go into open questions and answers. And the first one is to say, can you, panel, develop the theme of trust and how, in evolving a new approach to legislation and regulation, the need for trust can be taken into account, but not being a total dependence of legislation and regulation? Could I have a set of views from that? Stewart, do you want to kick off, and then Michael?
Yeah, I think, Sir Edmund, that the seed for trust is, of course, involvement and engagement, isn't it? So as we, or if we embark upon an analysis of a new legal framework, then we need to make sure that as many stakeholders in the community have an opportunity to contribute and we can listen to their views. So if it's merely perceived to be a conversation between police officers and government, you're going to understand that people won't trust it. So we need to spread the debate as wide as we possibly can, recognising that there are a multitude of valid perspectives that are required. That's the beginning piece. Beyond that, to me, the key custodian of trust when things go wrong is the courts, not regulators. And the way we've structured legal systems so far is to end legal analysis with regulators. Things don't go beyond regulators. So you don't see any case law about security or case law about privacy and data protection because it ends at the gate of regulators. We need to make sure that there's a strong and robust function within the judiciary to deal with ultimate concerns about trust.
Michael.
I would say some of this is an architectural issue. It's commonplace to say that the Internet is a place where you want to maximize anonymity. And, there's an old cartoon in the New Yorker, goes back a number of years, with one dog talking to another dog. And the first dog says, on the Internet, nobody knows you're a dog. And that joke is, emblematic of the kind of prize sense that you want to be anonymous on the Internet. And there's certainly good reasons why, in many cases, you want to have anonymity. But anonymity is the opposite of trust, because you don't know who you're dealing with. And so the answer may be multiple architectures. When you're dealing with your bank, anonymity is not a virtue. And banks ought to have the ability, perhaps they ought to have liability if they fail to put into place business processes that require robust identification. If you're on posting online having to do with political issues, perhaps there you want to have anonymity. And where the legal system can play a role here is by using a combination of tools. At the light end of the scale, things like safe harbors and liability protection if you put certain measures in place. At the heavy end of the scale, regulation or even taking over operating maybe critical infrastructure, which I'm not advocating, but I'm just laying out the spectrum. So I think you've got a range of outcomes you can tailor for the particular type of function you're worried about, and a range of tools to drive towards that objective.
Stephen?
So I think if they're going to create trust, then we can't tolerate the gaps in the system. So, for example, I mentioned in my opening that when you look at the way that regulation and law applies in a changing environment like privacy, if there are gaps in terms of accountabilities, then it will simply fail to deliver the trust that needs to be delivered. So I'll pick up on what Stewart said. I think that there needs to be a multi-stakeholder process in terms of understanding the role of government, the role of the courts and the role of regulators, but equally within the economic participants, the industry players, understanding their respective roles and responsibilities between each other, and ensuring that not just there are trusted relationships, but those trusted relationships are supported by the force of the law to ensure that standards flow down through the system, and it's that entire end-to-end process that delivers trust for the end user from the citizen.
Thank you. I'd like now to extend that theme into that of consultation. Government's record for consultation, timely consultation and sufficient, and then taking note of what the feedback is not good. I'd like to ask for ideas as to how this could be effectively done, not just on a national but an international basis, and how we should take account of the following generation who will be heavily influenced by the legislation and regulation that emerges. So two strands to the same thing. One, where's good practice about consultation, and how do we adequately take account of the use perspectives of this important area? Michael, would you like to kick that one off?
I think the challenge with consultation is, and in the United States, we've talked about this for ages, and there have been papers and reports and hearings, and so I think there's a lot of information flowing. But the big challenge I've seen, frankly, has been some of the critical information you need to make an intelligent contribution is very technical. And policymakers sometimes run out of knowledge, and so the conversation takes place on a technical level, but one that's staff, and then at the policymaking level, they don't have sufficient technical awareness. But a bigger problem is, frankly, a lot of the information in the data is secret. And it's secret for a good reason, but it is a cumbersome process that makes it difficult to have a tangible conversation, because as soon as you get into the details, the community that has access to the secrets can't reveal them because of fear of compromising sources and methods. That, by the way, lends itself to the skeptics who say the whole thing is overblown, which is what a segment of the audience says almost about everything. And that's compounded in the international arena, where there'll be an extra sensitivity. So we've got to figure out a way to be a little bit more forthcoming about things that are being held confidential. And on the legal issue, I would only say we do have to recognize that it's impossible to build a rigid legal framework that will anticipate things yet to come. And therefore, I think flexible regulations, result-oriented and outcome-oriented rather than prescriptive regulations, things that allow people to adapt to get to a particular end, are likely to be in the long run more capable of dealing with evolving requirements.
Let me just pick up on what Michael just said there in terms of the outcome-focused approach. It's something that we feel very strongly about, which is that the model of consultation has been consultation in the context of a sort of a command and control style way of regulating. And actually, when you look at security, or if you look at privacy, policymakers don't actually know quite what outcomes they're trying to achieve. They know what direction they want to head in, but it's a changing environment. And it's not just that the the international environment is changing, the economic environment is changing, and the technological environment is changing. But as Sir Edmund said, attitudes and behaviours and perspectives are changing. So as the next generation comes through, there's a set of expectations and requirements and desires that may take the current generation by surprise. So consultation hasn't just got to be an important part of developing the legislative process. It needs to be a part of creating the norms and standards that we actually deliver. And I think this is a feature with every area of development of technology or business models that are very rapid. It's very difficult for us to craft in advance what we think the solution should be for, say, 10 years' time from now. One thing certain is that the way we think about privacy is going to be different to the way it is today. So let's create an open consultative framework that allows us to find those solutions as we go, learn from experiences on the ground, and continually adapt. So consultation is important not just at the framing stage of working with policymakers in different parts of the world, but should be a fundamental part of the way norms and standards are created.
Stewart, can you envisage the web being used for consultation to address this in a way that would be manageable to legislators and regulators?
I don't see any technical barriers to creating some kind of online process to take people's views on questions, Edmund. And I think it's a sensible thing to do. The problem with consultation is very often, aside from Michael's point about the technical complexity of the subject matter, is you feel that there's a foregone it's a foregone conclusion, and it's really just a process that's being driven through to tick some boxes. So to give a for instance the point I'm trying to make, there have been a number of recent consultations about data protection law. And I can promise you, as you can imagine, Sir Edmund, I've spent many, many hours working on consultation responses to absolutely no result. There isn't any sense after submitting these that they're read or that they're going to influence any outcome. And there's me, a person who's engaged, and I'm at the point of giving up. But let me take a different perspective. If you look at some of the stuff that Brussels is agonising on at the moment, it shows you how ludicrous the law reform process is. So Brussels is agonising about the right to be forgotten. In some paternalistic sense, we need to protect the kids from Facebook. And I imagine if you could reach out to the kids, they would probably wouldn't want governments to spend so much of taxpayers' money on such wasted endeavour when there is much more serious things to do. So what we have is that there is a huge generational gap where a very small cadre of bureaucrats are shaping the legal environment that most of us, people younger than me, wouldn't even buy into or recognise as being important. So being able to get past those barriers into the online community would be exceptionally important, and I imagine they would tell us things that we didn't want to hear.
This sounds like a very appropriate topic for East-West Institute to pick up and develop. A very real connection between the issue of trust and a genuine consultation process. I'm now going to open this to the main forum. Can I ask the team to put the lights up, please? The form for this would be conventional. Can I ask you to raise a hand if you have a question? Please stand up, say who you are and who you're representing here, and then give me your question, and I'll pass it to a member of the team. We have one in the background. Sir, please.
Pavan Dugal, President, Cyber Law Asia and Advocate, Supreme Court of India. Congratulations to the panelists for a wonderful, diverse issues that this panel has dealt. I have a comment and a question. Comment first. Last 50 days, India has joined the select group of nations of the world to come up with a new regime on privacy. In fact, it's come up in the context of the outsourcing work being done to India. So not only has sensitive personal data been defined in very broad terms to not only just include your bank details, but your own biometric details, and even issues pertaining to your sexual orientation or your health or medical records, as also passwords. But more importantly, huge amount of responsibilities have been put upon intermediaries and service providers for ensuring that the sensitive personal data which they are handling, processing or dealing with is adequately and securely protected. And apart from that, there are various obligations of due diligence that India is now demanding these service providers to do when they're dealing with the sensitive personal information. That's my comment. My question now to the panel is, you are, as Michael said, you're violently in agreement that there's a need for change. But given two important issues that are coming forward, I would like to hear the view of the panel. Number one, cloud computing is the reality of the day. And with cloud computing coming in, privacy assumes a different connotation altogether. Number two, mobile internet is going to be the next big thing. Already it's being perceived that the mobile internet will be 5 times bigger than the PC internet that we know of today. Now, these two realities, when seen in the context of working along with each other, are likely to put far more challenges to the entire two rights that we're talking of, right to privacy and the right to cybersecurity. I would like to talk about the right to cybersecurity as a right of every netizen. Now, my specific question, what does the panel think as to how the law should adopt to these challenges of mobile internet, of cloud computing, specifically in the context of these two rights to privacy and cybersecurity, and given specifically the role of service providers and intermediaries? Thank you.
So what might the principles be that underpin a root and branch review of that kind? In no particular order, laws and regulation should enable traffic to move smoothly and safely for the benefit of users and for future generations. Those responsible for drafting that new framework for legislation and regulation must understand the evolving doctrine for exploitation of information around the globe, lessons learnt or lessons identified from past dramas, the environment and how it's likely to evolve, both in terms of commerce and international security. It needs to look at how regulation and legislation should be and could be implemented. It has to include rigorous, thorough and real consultation, and that should use the web. There should be absolute clarity about definitions of terms and of accountability. I believe it should be sufficiently simple for ordinary people to comprehend and to implement. It should incentivize the building and sustaining of trust nationally and internationally. It should be appropriate for an increasingly interdependent community within and across public and private sector boundaries and extended international supply chains. It should be road-tested with generations X and Y, who will inherit this as our legacy to following generations. It should have some form of embedded flexibility, and the law has not been accused of flexibility over the years. And it should invigorate business, government, and policy development. Now, I may not have done justice to that, but I think we'd all agree that this is of crucial importance to us as individuals and as nations and commercial and strategic partners. May I, on your behalf, thank the team for their patience, persistence, and for making such a complex issue so clear. We've clearly got important work yet to do, and thank you for listening.